Well, good afternoon, Michiganders. It is Tuesday, January 19th, and this, of course, is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Just a note about a recent upgrade to the Tuesday with Tom website. If you haven't been there for a while, I suggest you check it out because now you have the ability at the website to search the 200 plus podcasts that we have now had about estate planning and estate settlement in Michigan. So if you have a question that comes to you, perhaps what's a will, or do I need a living trust, or should I make my children joint trustees on my trust, whatever it happens to be, I suggest that you go to the TuesdayWithTom.com website and run a search, and you will likely find a podcast in which I have discussed the very topic that you are interested in. Although, if I haven't, as I say at the end of every program, shoot me an email, Tom at TuesdayWithTom.com, and we'll look at incorporating your questions into a future episode. Well, last week's episode, speaking of episodes, was watch for these two potential estate tax changes under the new administration. A new administration comes in, looking at changes, and I discuss two of the likely tax changes, federal tax changes, that will be implemented by the Biden administration that is going to likely affect most estates. So I suggest that you listen to last week's episode so that you can keep an eye on, is this something that's going to apply to you? If so, keep an eye on it during the year to see if either or both of these potential estate tax changes do get implemented, and I think they likely will because of the amount of money that the government is spending to fight COVID. The trillions of dollars that are being spent have to be made up somewhere, so there's likely going to be tax changes, including the two that I discussed in last week's episode. Today's show, something that Amanda and I are frequently asked about when we're looking at putting together an estate plan. It comes up probably with most clients that we're talking to, and that's the question, what is a Michigan Ladybird deed? But please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your particular estate plan. What is a ladybird deed? Well, first, let's just start with a more general discussion of deeds. As you likely know, deeds are the legal documents that are used to transfer real estate. And side note, it transfers the real estate, i.e. the land, but it also includes any dwellings that are built upon the land. We get this question kind of all the time. You know, Tom, I bought an empty lot. I got a deed for the lot. I've now built a house, but I never got a deed for the house. No, you don't. You don't get a separate deed for the house. You buy the land, you have a deed for the land, and when you sell the land, that will include any home that you have built on it. Similarly, I guess not the same. Not similarly at all, I guess, when you look at it. Mobile home. If you have installed the mobile home, if it's become like these double wides that become part of the property itself, then yes, that's going to include the home. But if it's a traditional mobile home where perhaps you still have the wheels on it, Then you're going to have a deed for the lot or the real estate, and you're going to have a separate title for the mobile home. But generally speaking, a deed is what we use to transfer real estate. And there are two basic deeds that we need to have a clear understanding of or would be helpful to. One is a warranty deed, and the second is a quit, and that's Q-U-I-T, claim deed. So what are they? Well, a warranty deed. A warranty deed is something that you always want to insist upon when you purchase or receive property from somebody else. Why? Because in a warranty deed, and the key is the name warranty, the seller guarantees, i.e. warrants, that he or she owns the land free and clear unless the deed indicates that there are any sort of restrictions on the property. Perhaps there are easements that have been previously placed on the property. But generally speaking, under a warranty deed, the seller is guaranteeing that he or she owns it free and clear. What does that mean? What that means is if it turns out down the road that somebody else comes in and can make a claim to the property and establish that they in fact have ownership rights that precede your ownership rights, then in that case you can sue to get your money back because the warranties have been breached. That essentially is a warranty deed. Now, normally, when you're buying property, you're also going to want to get title insurance when you're purchasing the property. And the reason for that is if you sue the seller for breaching the warranty, but they don't have any money to collect from, you want to make sure that there's a title insurance company that will in fact make it good, which is why you always want title insurance when you're buying property from somebody else. So warranty deed, seller guarantees that they own it. A quit claim deed, again, Q-U-I-T, not Q-U-I-C-K, quit claim deed. Under a quit claim deed, there are no guarantees or warranties made by the seller. Essentially, they're saying, if I own it, I'm transferring it to you. If I have any interest, whatever that interest is, I'm transferring it to you. But if it turns out I don't own it, you can't sue me because I'm not making any guarantee or warranty that I own it. Let's use an example. Let's take a building. Let's take the building downtown Lansing. I'm thinking of a bank building downtown Lansing. If I today gave you a deed to this particular bank building downtown Lansing, if I gave you a warranty deed, and it turns out after the fact that you discover that I did not own the bank building, you could sue me to get your money back. On the other hand, if I gave you a quit claim deed to the same building, and it turns out down the road that I did not own it, you could not sue me because I simply gave you anything that I had. What does that mean? Basically, warranty deeds are something that's going to be used when you buy property from somebody else. A quit claim deed is oftentimes used when there's a question about a title. You're using it to clear up some question about the title. You're not really worried about someone guaranteeing or warranting. Oftentimes they are used to transfer property into a living trust. Although, and we get a whole nother episode as to perhaps why we might choose to use warranty deeds even when we're transferring it. Maybe you're transferring property to a family member. Maybe you're going to transfer it to your children. And it's not really a question of whether you guarantee it or own it. You know you do, and you're simply transferring it to a family member. Which brings us to today's question then, what is a ladybird deed? Well, a ladybird deed can be either a warranty deed or a quitclaim deed. So it doesn't matter as far as a ladybird deed, whether it's going to be a warranty deed or quitclaim deed. And in fact, I know this gets a little bit confusing sometimes for clients. The deed itself, that's a ladybird deed, doesn't say ladybird deed on it. The caption of a deed is either going to be warranty deed or quitclaim deed. You're not going to likely ever see one that says Ladybird deed at the top. It's simply a type of warranty or quitclaim deed. Essentially, it's also sometimes what we refer to as an enhanced life estate. So what does that really mean? Under a Ladybird deed, well, let me step back a little bit. We can, when we have a deed to property, we can convey the property entirely, or we can perhaps convey what we call a life estate in the property, or retain a life estate in property. And so, let's say I'm going to deed the property to my children, but I want to continue living in the house for the rest of my life. In that case, I might have a deed in which I convey the property to my children, but I retain a life estate. That is the ability to live in the house for the rest of my life. Now, what does that mean? That means my children could sell the real estate, but I would still have the right to live in it for the rest of my life because I retained that life estate. Well, essentially, a Ladybird deed is what we'd think of as an enhanced life estate. Now, it's a lot of technical legal jargon, I imagine, but here's the way we suggest you think about it. Think of as a Ladybird deed as though you're putting a beneficiary on your real estate. It's still your real estate. You can still live in it. In fact, you could sell it to somebody else if you wanted to. You can get a mortgage on it. It's still yours. But, and this is the key, upon your death, it now is automatically, without having to go through probate, owned by the person or persons who you have named in the deed. So that's the way to think of a Ladybird deed. It is as though you're putting a beneficiary on your real estate. Again, you maintain control over their property during your lifetime. You can sell it, you can mortgage it, you can do whatever you want to do with it. So what are some of the advantages of having a Ladybird deed? Well, one advantage is it does avoid probate. Upon your death, the real estate is now automatically owned by the person or persons whom you have named on the deed. A benefit to the individual who is the, quote, beneficiary on your deed is that under current federal law, they will receive what we call a stepped-up basis in the property at the time of your death. And that means for capital gains purposes, their basis is whatever the property is worth on the date of your death. Now, if you're concerned about what's going to happen to stepped-up basis, in the Biden administration, that's one of the things I actually discussed in some detail last week. It's also, in many cases, a better arrangement than joint ownership. A lot of clients will look at making their home jointly owned with their child. Well, if you make it jointly owned, and you can go back and listen to previous episodes of this program where I talk about it, some of the issues with joint ownership of real estate is that you lose control over your property. You can't just sell it when you want to because you have a child who's on it as an owner. There are possible gift tax consequences to adding your child onto a deed as a joint owner. And if you make your deed jointly owned with your child, now it is going to be subject to any claims that might be made against your child. Let's say they have an automobile accident or they go bankrupt or they go through divorce, whatever it happens to be. Well, a Ladybird deed avoids all of those problems. Why? Because your child doesn't own it until your death. That means you didn't lose any control. That means you didn't make a gift. And that means your property isn't subject to any claims that might be made against your child. Well, why do we use them? Let's look at, now that we have a general understanding, a Ladybird deed is basically, for all intents and purposes, as far as clients concerned, putting a beneficiary on their home. Why do we use them? Well, one of the areas where they were and are still most frequently used is Medicaid planning. Under Michigan's Medicaid law, and again, if you want more information about this, do a search at TuesdayWithTom.com because I've talked about this before. Under Medicaid, after you die, the government is supposed to come after your probate estate to get their money back. However, they can only go after your probate estate. Those are assets that go through probate. If you have a home and you have a ladybird deed on your home, when you die, that home does not go through probate. Therefore, it is not generally subject to this Medicaid recovery law in the state of Michigan. But there's another important one that fits in oftentimes when people have trusts. You might have a trust, a living trust, and if you transfer your property during your lifetime to your living trust so that the trust owns it, and now you apply for Medicaid, it is no longer exempt. It means it has to be sold. Why? Because a home is only exempt under Medicaid if you own it. So if your trust owns it, it's no longer exempt. So in the Medicaid planning world, what normally is done is if you have a trust, you don't transfer ownership of your home to the trust now. Rather, you use a ladybird deed that will transfer ownership to your trust when you die. That way, it's still your home. It's still exempt as far as Medicaid is concerned, meaning you don't have to sell it to qualify for Medicaid. But then upon your death, it will automatically be owned by your trust, and that way it avoids probate and avoids the recovery law, which is one of the issues as part of probate planning. Again, so one time that we're going to look at using ladybird deeds is certainly in Medicaid planning. But beyond that, in general estate planning, ladybird deeds have a place. One, perhaps your estate is one, and this again looks at your estate plan, what you own, who it's going to, what you're looking at trying to accomplish. But perhaps when you look at your estate plan, you have decided that you can accomplish all of your estate planning goals by using beneficiary designations. You put beneficiaries on your bank accounts, you put beneficiaries on your life insurance, you put beneficiaries on your investments, etc., and you're left with your house. Well, now one of the things that you can do is essentially put beneficiaries on your home. So it avoids going through probate. So it's a very common tool that we find ourselves using today when there aren't reasons to have a trust otherwise, and client is able to use beneficiary designations to accomplish all of the estate planning goals that they have. We oftentimes simply use a ladybird deed as one more quote-unquote beneficiary designation as part of that overall estate plan. So it's not just related to Medicaid planning. It's not just related to trust, but it can be part of an estate plan even where we're not going to have a trust. Even if you have a trust. Even if you have a trust, generally today, we in our office are more likely going to use ladybird deeds as the tool for putting your real estate in your trust. Why? One, because we don't know if maybe down the road you're going to go on Medicaid or you're going to apply for Medicaid, and we don't want to have a situation where that occurs and you find out at that time that your home is no longer exempt. So generally speaking, Amanda and I are in fact using ladybird deeds even when we're looking at conveying property into a trust. Now, something to remember though, a ladybird deed, just like a trust, just like a will, a ladybird deed is not an estate plan. However, it might be one of the appropriate tools when we're looking at how do we accomplish your estate planning goals. Something to keep in mind, though, with a ladybird deed. Think about this. When you have a ladybird deed, upon your death, your home is now automatically owned by the beneficiaries. It's no longer owned by you. So it is important to consider your homeowner's policy when that ladybird deed is created. If you have a home and the homeowner's policy is just in your name, and when you die, now that home is owned by your children, that does not automatically convey to your children the homeowner's policy. You now have new owners on the home, which is not you. Meaning what? If you die and your children don't go to an insurance company and insure the home, if the home burns down in the meantime, the insurance company that you had is not going to cover it. Why? Because you're dead and you no longer own the home. So an important thing to do with your insurance, and we recommend clients do this when they have ladybird deeds, is add the beneficiaries, whoever the home is designed to go to at the time of your death, add them as additional named insureds on your current homeowner's policy. Why? Because when you die, if they are additional named insureds on the policy, at least they will be covered per a period of time until they have an opportunity to get insurance on their own. So it's one of those things that's important consideration. If you don't do that, certainly you want to alert your beneficiary to the fact that when I die, one of the first things that you need to do is contact a homeowner's insurance company and get the home adequately insured. One other thing with ladybird deeds, they're not available in all states. In fact, last time I checked, I think they are not available in most states. Now, in states that they are available, Florida being one of them, I believe, they don't call it a ladybird deed there. They call it, an enhanced life estate deed. So it might not be called a ladybird deed in the particular state that you're looking at. And even in the state of Michigan, some attorneys are going to refer to them as an enhanced life estate deed. If that's something that you think might be appropriate for your estate plan and you have any questions about that, Amanda and I would be happy to talk to you to help determine whether or not a ladybird deed is an appropriate tool to be used as part of your estate plan. Of course, Amanda and I would also be honored to have the opportunity to assist you with putting together your estate plan, or amending a plan that you already have, or, of course, in ultimately settling an estate. And if you, because of COVID, and we talked about this before, we're not currently seeing clients in person. Everything's being done by Zoom calls, by telephone calls, etc. But if you head on over to the virtual office at DoyleLawPC.com, you're going to find a number of options that will be available to you. If you are not already a client of ours, you're going to find information on our Planning from Home service. That's where you can have an estate plan prepared for you entirely, beginning to end. We'll have a Zoom call or telephone call, whatever it is you prefer. You'll have the ability to download our estate planning guidebook that gets you started. So if you're a prospective client, take a look at the information that's available under the virtual office. If you're a current client, again, go to the virtual office and you're going to find information about the Update My Plan service. That's where you're going to tell us what changes you want to make to the plan that we've already put together for you, and then we will let you know what is required to make those changes. Again, you have the ability under the virtual office, schedule a consultation, a Zoom call, or telephone consultation with us. The third option, I guess, if you know what legal document you need, maybe all you need is a new certificate of trust because you're trying to sell real estate for a trust, or you simply need a new durable power of attorney, then simply look at the legal store that, again, is available at doylelawpc.com. There you're going to find the ability to order individual legal documents such as certificates of trust, powers of attorney, etc. Well, that's it for today's show. As always, though, if you have a comment about the program, a topic that you'd like to have me discuss, or questions that you'd like to have answered, again, head on over to Tuesday with Tom, do a search to see if we've already talked about the topic, perhaps. If we haven't, or you have still questions about it, or you just have questions again, send me an email, tom@tuesdaywithtom.com. Mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. And as always, we do invite you and your friends and family to follow us on Facebook and Twitter. That would be Tuesday with Tom. Follow the office as well on Facebook and Twitter at Doyle Law PC. Remember, too, the Tuesday with Tom app is available in the App Store and Google Play. The program is also available on Apple Podcasts, Spotify, Google Podcasts, iHeartRadio, Spreaker, etc. And you can always ask your smart speaker to play Tuesday with Tom. Well, thank you again for spending some of your Tuesday afternoon with us today. As always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.